Committee will come to order. Good afternoon. The House Armed Services Committee meets this afternoon to receive testimony on law of war detention and the President's recent executive order. Before we begin, I want to provide notice to all members that I'll be departing with the regular order of questioning by Republican members. Consistent with Committee Rule 11, Ranking Member Smith has provided his concurrence for us to proceed in this manner. As you all know, we're approaching the 10-year anniversary of the devastating attacks of September 11, 2001. It's also been nearly 10 years since Congress authorized the war in response to those attacks. As we approach that solemn marker, we need to ensure that our men and women in uniform have the legal authorities necessary to target and detain those who seek to harm us. It's time for Congress to show leadership in this area and not continue to leave it to the courts to define our enemies and circumscribe the parameters of war. While I support an administrative review process designed to ensure the continued detention of each Guantanamo detainee is necessary, I have significant concerns about the review process established pursuant to the President's executive order issued last week. Detainees currently have nearly unlimited access to lawyers for their habeas cases in Federal court. According to personnel at Guantanamo, there were over 1,400 legal visits to detainees in 2010. These cases are taking years to resolve, involve intense resources, and necessitate hard questions regarding how to protect sensitive intelligence sources and methods. I'm concerned that by involving lawyers in the administrative review process, what is supposed to be an administrative evaluation of the threat posed by the detainee will turn into yet another opportunity for lawyers to embroil our military in endless litigation. I also fear that because of our concerns related to potential litigation, we're not capturing terrorists whom we need to neutralize and question for intelligence purposes. Without a comprehensive approach to detention, we'll continue to lose out on opportunities for critical intelligence gathering. This is also true at home, where we lack the flexibility needed to conduct extensive intelligence interviews of terrorists like Christmas Day and Times Square bombers. There may be a number of different solutions to this problem, and I'm open to all of them, but something has to change. I was heartened by the President's speech at the National Archives in May of 2009 when he said that he was committed to working with Congress to tackle these challenging questions. I've been very disappointed that those have turned out to be empty words and that the President has decided instead to go it alone. I hope in the coming days and weeks we'll see a reversal of this trend. I look forward to addressing those challenging issues with the administration, my distinguished colleague, Ranking Member Smith, and all members of the committee. Lastly, we cannot allow ourselves to become so caught up in the details of these issues that we neglect our fellow citizens who lost so much nearly 10 years ago. Missing from the President's announcements last week was a commitment to move forward with the prosecution of those responsible for 9/11 attacks and provide a full and fair airing of the war crimes they committed. We cannot forget about the justice that the victims, their families, and the American people deserve. To address these issues, we're joined today by the Deputy Secretary of Defense, William Lynn, and the General Counsel of the Department of Defense, Jay Johnson. Gentlemen, thank you for appearing before us today, and I look forward to hearing your testimony. Ranking Member Smith.
Thank you, Mr. Chairman. I appreciate you holding this hearing on this critically important issue, and I certainly agree that we need a better and clearer process for how to detain and interrogate those terrorists that plan attacks or commit attacks or threaten us. It's a very difficult area of the law to strike the balance. I think the President's speech that the Chairman referenced from a couple years ago did a good job of doing that. It acknowledged the fact that we were going to need military commissions and even acknowledged the fact that there were going to be some people that we were going to have to hold without trial. But the President also very much emphasized that in doing that, we need to follow the law. and we need to have a clear process in place for doing that. And I agree that that needs to be an executive and legislative branch priority, and that the two of us have to work together. The two groups have to work together to make that happen. And I also want to thank the Chairman. He and I have had a number of discussions on this issue going in terms of how we work it out going forward, and I appreciate that bipartisan approach. And I agree that we need to improve the process we have now. I do want to point out that the legislation that the majority introduced last week, I feel actually moves us in an even more dangerous direction and does not address those issues, and that there is another side to these concerns, and that is we have to have a legal framework in place that upholds our Constitution, that upholds our values. And I think we have to do that for two reasons. One, it is part of the broader message in our struggle against al-Qaeda and their ideology to say that what we do here is superior to what they want to do, that freedom, opportunity, respect for individual rights is a critical piece of what makes our country great. We cannot broadcast that message broadly to the world and then contradict it in our very own policies. And I think even the majority would agree we've paid a price in some of the early ways that Guantanamo Bay was set up and what happened in Abu Ghraib for not doing that. And the legislation that was introduced last week, I feel, pushes us back in that direction. It gives too much power, ironically, to the executive branch and too much power to the military to decide who to hold, by what standards, and then to have very little process in place for that to be reviewed by anyone outside of the military. We need to make sure that there is a fair process in place for the reasons I stated before, but also to make sure that we can hold these people. The courts will step in if they feel that there is not a fair and constitutional process in place. We saw that happen in Guantanamo in the first place, where they stepped in and said habeas corpus is going to apply and began having review processes based on that has led to the release of some inmates there. So we need to have that process for our national security as well. And the final piece of this that I want to make everyone aware of, that is contained in the legislation that was introduced by the majority last week, is the fact that it turns Guantanamo Bay into, if you will, the Hotel California. You can check out any time you want, but you can never leave. That is not a sustainable situation. It makes it clear that nobody in Guantanamo, and that includes not just the people who are there now, but the people that certainly we're going to bring there in the future under the majority's piece of legislation, because we are far, far from done with this issue, cannot be transferred to the United States at all, ever. But it also sets up a series of restrictions for transferring any of these people back to their home country that are impossible to meet. You can read through the requirements that are there, but the Secretary of Defense himself has said he would never certify a transfer back to the home country based on the requirements that are in there. And think about that for a minute. If we pick up somebody by mistake and take them to Guantanamo, we are still in no position under this legislation to ever let them out. That is extraordinarily problematic from a policy standpoint. And beyond that, even if you have people who you pick up and convict and serve a certain sentence, when they're done serving their sentence, the legislation again has no contemplation whatsoever for how to ever let that person out. So I do agree with the majority that we need to do better than we've done. I'll even agree with the majority that there have been some missteps by this administration in how they handle this process. But I hope going forward we'll work together to come up with a reasonable solution that balances all of our interests. And I think this hearing is meant to begin that process. I applaud the Chairman for doing that. I look forward to continuing to working with him and the administration to get us the right solution on this very important public policy matter. Thank you, Mr. Chairman.
Thank you. We've been told, I think, that we could be having votes any time, which is unfortunate. But why don't we get right into your testimony, Secretary Lynn?
Thank you very much, Mr. Chairman. We have a longer written statement that I propose that you put in the record, and I'd summarize it for you here, and then we
without objection, so ordered. Thank you.
And then we'll just turn to your questions. First, I want to thank you, Mr. Chairman, and Congressman Smith for holding the hearing and giving us the opportunity to testify. Also appreciate the courtesy your staff availed us of in scheduling the hearing so that we could do it as the administration has announced some important policies that you referred to. And the major announcement there was on March 7th, 2011, where the President announced several initiatives related to the legal framework for detention of detainees, including the detainees at Guantanamo Bay. We are here today to discuss those initiatives and any other questions that you might have. As a preliminary matter, I need to note that President Obama remains committed to closing the detention facility at Guantanamo Bay. But regardless of where the detainees are located, we would be pursuing the initiatives that he just announced. We in the Department share the President's view that these initiatives will strengthen our national security and at the same time promote the rule of law. Our goal is to ensure a system of detention that is balanced and fair with respect to the detainees and is sustainable and credible with the U.S. courts, the Congress, the American people, and our allies. First, Secretary Gates has lifted the suspensions on new charges in military commission. The suspension was issued by the Secretary in January of 2009 to permit the new administration time to review the status of each detainee at Guantanamo pursuant to Executive Order 13492. That review is now complete. We have also worked with the Congress to reform military commissions, most notably through the Military Commissions Act of 2009, which was passed with bipartisan congressional support. With that piece of legislation and other reforms, we believe that the military commissions, along with federal civilian courts, are an important tool to bring detainees to justice. At the same time, we respectfully disagree with the restrictions that the Congress has imposed on transferring Guantanamo detainees to the United States in order to prosecute them in federal court. As the President has made clear, and as the Secretary of Defense has stated publicly, we must have available to us all tools that exist for preventing and combating international terrorist activity and protecting our nation, including the option of prosecuting terrorists in federal court. Second, the President signed an executive order that provides for the periodic review of those Guantanamo detainees who will be held in long-term detention. As the President recognized in his National Archives address that you both cited, there are certain Guantanamo detainees who, in effect, remain at war with the United States and thereby pose a continuing threat to the security of the United States, but who have not been charged, convicted, or designated for transfer. For this group, the President said, we must have a thorough process of periodic review so that any prolonged detention is carefully evaluated and justified. The new periodic review process announced earlier this month satisfies that directive. It strengthens our national security by providing a solid and sustainable system for the review of individuals who have been designated for law of war detention or who have been designated for prosecution but against whom no charges have yet been brought. Third, the President announced that the Administration will seek Senate advice and consent to ratification of Additional Protocol 2 to the 1949 Geneva Conventions. This treaty is applicable in non-international armed conflicts, such as our conflict against al-Qaeda. The President also announced that he will follow, out of a sense of legal obligation, Article 75 of Additional Protocol 1 of the Geneva Conventions in international armed conflicts. Over the years, international legal experts from across the political spectrum have called upon our government to embrace these provisions. After careful analysis, we have concluded that the practices of our military are already consistent with them. By embracing these two sets of safeguards, we promote the international law of armed conflict, including in our current conflict against al-Qaeda and its affiliates. We also send the message that we expect others to adhere to the same standards. Overall, we believe these initiatives will promote clear, credible, and lawful standards for the detention and prosecution of those who remain at Guantanamo. This in turn benefits our national security as well as the safety of the American people. With that brief opening, Mr. Chairman, happy to take your questions.
Thank you. Mr. Johnson.
Mr. Chairman, Mr. Smith, I'm happy to defer to my colleague in his remarks, and I look forward to your questions.
Thank you very much. I'm going to defer my questions till later, so I'll ask Mr. Thornberry. I yield 5 minutes to him.
Thank you, Mr. Chairman. And Mr. Johnson, I would like to start out on the authorization for the use of military force, because I think that is a basis upon which a lot of the rest of this depends. The resolution, which was passed September 14, 2001, talks about those who planned, authorized, committed, or aided the terrorist attacks that occurred on September 11, 2001, or harbored such organizations or persons. Surely, as 10 years has passed, and Al-Qaeda and other groups have evolved, it becomes increasingly difficult for you to authorize various actions that most of us agree need to be taken to protect the country, and relating it all back to the attack of September 11th. Is that true?
Congressman, that's a very good question. Thank you for that question. When I assess the legality of our operations against al-Qaeda and its affiliates, I look to the language you read as well as our definition of detention authority that we put out March 13, 2009, which I think is useful in informing our military activities and operations generally. That definition refers to associated forces, which is a well-accepted, recognized interpretation in the law of war. That said, I will agree with you that the conflict against al-Qaeda is evolving because that organization is evolving. It is more decentralized now than it was 10 years ago. I think that the current legal interpretations of the AUMF that we have and that we've used, which are solid, are sufficient to address the existing threats that I have certainly seen and that I've evaluated. So I think it's worked so far. I believe, however, that we should carefully look at the language in the Chairman's bill and in the Senate bill, which in effect, reauthorizes military action, and evaluate it and have a serious discussion about it. I'm inclined to say that the existing authority is sufficient, but I think this is a serious discussion to have.
Well, as you well know, the D.C. Circuit in the Bahani case was looking for statutes to help scope the executive's detention authority, and they looked at the Military Commissions Act, but as they recognize, we have the legal authority to detain under the AUMF greater than those individuals that we can prosecute under the Military Commissions Act. And so I guess the obvious question you just mentioned, the policy you use includes the word associated forces. Would it not be a good thing to put associated forces into a renewal of the authorization for the military force? And doesn't that give you and the courts a stronger basis upon which to make decisions rather than a policy, to have it actually in statute?
Congressman, I don't have an administration position for you on that, but I think that that is something that we should seriously think about.
Well, I hope we can do more than seriously think about it, because it concerns me that as we go further and further from 9/11, that the stretch back to those who planned, authorized, committed, or aided in those particular attacks on that particular day is going to be more challenging. And as I mentioned, the way that al-Qaeda and other groups are moving around the world and evolving is going to require either that we stretch language beyond real meaning, or that we try to update our laws to keep track of the changes that are happening in the world. And I hope we can come to agreement on that. Mr. Chairman, I yield back.
Thank you. Ranking Member Smith.
Thank you, Mr. Chairman. I want to try to focus on the legislative proposals that the majority has put forward, because I agree, and I think you would as well, that we need legislation on this. The executive order is helpful and moves us forward, but to have Congress present a clear set of policies for how to proceed with the military commissions, how we're going to handle these people, would be helpful. But I am concerned by a number of aspects of that legislation and want to explore them and get your concerns. And the first area has to do with the complete turning over of this process to the military under the majority bill. Now, we have successfully tried many terrorists affiliated with al-Qaeda in Article III courts and incarcerated them right here in the United States of America, Ramzi Youssef perhaps being the most prominent, Zacarias Moussaoui and others as well. But this piece of legislation would preclude that and would require, if I read it correctly, even those who would be arrested attempting attacks here in the United States, and even if they're U.S. citizens, to be removed to Guantanamo and go through a strictly military process. There are, I believe, both legal and policy ramifications of that. It certainly empowers the military in a way over U.S. citizens that I think should be alarming to anyone who is concerned about giving the government too much power. I mean, the government in this situation would be able to pick anyone they wanted, and if the military says you committed a terrorist act or even assisted in a terrorist act, you would then have virtually no rights other than the basic habeas corpus right whatsoever. And I think that expansion of power is problematic, certainly for the broader policy argument. But let's talk about the legal piece of it and the concerns that if we were to do that, decisions to try or incarcerate would be subject to constitutional challenge, and that the courts might once again step into this process and force us to release people we'd rather not release because we're not following a proper process. Can you talk about that piece of it and why in some instances it still makes sense to have Article III courts as an option?
Yes. I've looked at the bill that was offered last week pretty carefully at this stage. One of the things that I had concerns about when I read it was the provision that said that anyone who is eligible for detention under the AUMF must be put in military custody unless the Secretary of Defense agrees to give him up. And just the phrase eligible for detention under the AUMF, and there was another piece of the bill that included in that definition supporters, people who are not part of the enemy but supporters of the enemy, would be swept up by that provision. So I have some concerns about the breadth of that language. I suspect that it would lead to it would give us litigation risk, without a doubt. And my more general comment is, but there are a number of provisions in the bill that I think are things that we ought to take very seriously and think about and carefully consider. I think it was a very thoughtful piece of work. The two other comments I'd have, though, is as this conflict evolves the way it's evolving, is let's not take options away from the military and our national security apparatus to meet those threats. Let's not take away the Article III option. Let's not take away the ability to transfer somebody to a particular place for reasons of national security. Don't restrict the military's options as we deal with this evolving threat. And the other comment I'd make is I think we need to be careful about, I think in terms of the controversy surrounding our detention, we're moving in a good direction. We're doing better in the courts. I think we've had 7 consecutive decisions in the habeas where the government has prevailed. We're doing better, and I actually believe we're winning back some credibility in the courts. I think we took some hits and we're winning back credibility. And so I think we need to be careful about provisions in legislation that will only make our detention practices more controversial and engender more litigation.
And if in winning back credibility, what that means is winning back the ability to withstand court challenge and be able to hold the people that we want to hold. I think a lot of times in this debate we've gotten lost in some of the broader arguments about, the messaging issues. And I think it's very real, and certainly al-Qaeda has used, Guantanamo, Abu Ghraib, as I mentioned, against us. But forget about that for the moment. I mean, they're going to use a lot of very creative things against us. But if we don't have that credibility with the courts, what that means is it will hamper our ability to hold who we need to hold for national security reasons. So I hope we understand that as we get into some of the other peripheral arguments about what's right or wrong. This is about being able to uphold the national security and be able to hold the people who we need to hold to protect us. The President has acknowledged that we need to do that, and in many cases we will have to hold people without trial because they, as you mentioned in your opening remarks, Mr. Secretary, that they are a clear threat to us and they still are at war with us. So I hope we'll keep that in mind. I have other questions, but I will hold them to the end.
Thank you. Let me just say something about the bill that we introduced last week. That was the start of a process. I mentioned in my opening statement that the President had talked to me earlier and talked about working together. I had hoped that that would happen before the executive order was issued. It kind of moved up the process on our bill. I would have loved to have had us all sit down together and come out right out of the chute with a bipartisan bill, but we're just starting the process. So we will have lots more discussion, and I don't think this is probably even the point to go into great depth on the bill because we will have opportunity to do that. And we will do it on a bipartisan basis. And it's far from, this is not a markup. And that will come somewhere down the road. But we will, I am totally truthful in saying that we will work on it in a bipartisan way. Now,
and Mr. Chairman, if I may, let me acknowledge that. I think that's very true. I just, once we get started, I think we do need to look at the language and make sure it doesn't get moving too far down the tracks before we understand the limitations. But I clearly acknowledge that you have reached out to me, and we are going to, go forward and work together on this in a bipartisan way.
Thank you. And the reason I even bring it up right now is I don't want us to get hardened on any positions before we have a chance to sit down and understand each other's positions. That's the only thing. I do not want this to become, get on a partisan track or anything else. That's not the purpose. Okay, Mr. Forbes.
Thank you, Mr. Chairman. Ms. Johnson, thank you for your service and the work that you do. Mr. Secretary, thank you for all that you are doing. And I heard the word today, credibility with the courts. But one of the things we've got to be concerned about too is the loss of credibility we have with our citizens across the country. Mr. Secretary, what would you tell them if they were to ask you what is the worst act of terrorism that has ever hit the United States soil? What would your answer be?
The attacks on 9/11.
And of the individuals that we at least view as defendants, how many of them are there and where are they currently being detained?
Several of the defendants are being detained at the Guantanamo Bay facility.
Do you know how many?
5, I believe.
You believe? You don't know right now for certain how many? 5 defendants. Do you know, we're now almost 10 years out, the charges that were sworn against them were sworn on February the 8th, 2008. They continued prosecution. They had 134 motions that the prosecutorial team was pushing against those defendants, the worst of the worst that, according to you, that have hit the United States. And Mr. Johnson correctly states that we shouldn't take away options, and yet you took away the major option that they had. The prosecutor said that he would have had guilty pleas and convictions within 6 months, and yet the administration came down and said no and dismissed without prejudice all that work that had been done on January 21, 2010. We are now past 2 years from that. Can you tell me, almost 10 years out, the 5 defendants, all of whom acknowledged that they did it, prosecutor that said we would have had them with guilty pleas and guilty convictions, when are they going to be prosecuted? Can you tell me the day that we're going to file charges against them at this particular moment in time?
As you know, Congressman, the Attorney General proposed that these charges be brought in an Article III court. He felt that given that the location of the attacks that you've cited were in the United States, given that the vast majority of the victims were American citizens, were civilians, not military, that it was more appropriate to try them in an Article III court. That has been blocked by congressional action, and the Attorney General is now considering how to respond to that action and proceed from there.
And it was blocked by majorities of his own party in the action that took place. So then right now we don't know when those prosecutions are going to begin. One of the things that's going to be important is that when they do begin, that we have the most experienced prosecutors that are prosecuting that case and these terrorist activities. What assurances can you give this committee objectively that you and the Secretary will make sure that we have the most experienced prosecutorial teams that are prosecuting those cases?
Well, if the cases, I think you're talking about the case of if the cases were returned to the Military Commission.
That's correct.
Which has not been decided. But if that were to be the case, we have kept the prosecution teams together in the Military Commission process, and we have ensured that we are able to utilize not just DOD prosecutors, but to tap the great expertise in the Department of Justice. So
are you telling me that you have the same team completely together that was prosecuting these 9/11 defendants before those charges were dismissed?
I don't think we've kept every individual, but we have kept the core of the teams together, and we would be prepared to act if that were the decision.
Who do you have together in that team on the 9/11 defendants now that you've kept together?
I can't give you a by name.
Would you follow up with me, please, and give me what part of that core team that you have still kept together?
I'm happy to describe.
Mr. Johnson, sure.
I could be wrong, but I believe it's the case that the prosecution team that was in place a year ago is still in place. I could be wrong about that.
Just follow up with me if you don't mind. I don't expect you to have the answer. And the only other two questions I'd have, and you may need to take these and get back to me, but what are the consequences of this delay? You know, we start having problems with evidence, problems with witnesses as it continues on. If you could give me an assessment, either you or Mr. Johnson, for the record, and also the consequences of doing this two-track system, which seems to me to be a very convoluted, difficult system for us to do. And, Mr. Chairman, my time's up, so I'll yield back. Thank you.
Thank you. Mr. Andrews.
Thank you, Mr. Chairman. We're very heartened by your very sincere words about a joint effort to try to address this very important problem. Thank you, and I know that we're going to take full advantage of that. I thank the witnesses for their testimony. I was looking at the testimony about the disposition of individuals under Executive Order 13492, the review process at Guantanamo. And I just wanted to walk through and make sure that we understood it. There were 67 individuals as a result of that process transferred out of Guantanamo. Is that correct?
67 since January of 2009, which is when the Obama process started. There were about 540 or so prior to that.
Where were they transferred to?
Variety of different nations. Some were repatriated to their home nation. Others were transferred to third countries where we got security assurances.
How many of them were still incarcerated?
How many of the 67?
Yes.
I'd have to get that for the record.
Could you do that for the record for us? And obviously the other half of that coin be how many are not incarcerated or free. Second, on the 36 who were referred for prosecution, how many of the 36 have been referred for prosecution in the Article III courts?
There were the 5 9/11 defendants, and I believe that I can't remember whether the 36 includes. I know the 5. There might be one other in that category. I can't remember offhand.
Is it fair to say that the others are in a position where there's a decision being made about whether to prosecute them under a commission or an Article III court?
Well, there were the 5 or 6 who have already been referred to military commissions, and then the remainder we have to still divvy up.
Do you have
remainder
some
of the
sense of
36.
when you're going to make the decision as to whether to prosecute them in a commission or a Article III court?
We're working that right now.
Okay. And then there was the 48, my understanding, are still detained under war authority. This is not meant to be a rhetorical question, but do we know how old all of these are not related to 9/11, correct? They're not all authorization of force of 9/11, is that correct?
They're all they're all detained under that authority.
Okay.
But they're not all squarely
What is
responsible for
what is
9/11.
the latest date of a material fact for one of those detainees? In other words, some of the facts are on 9/11, some of the facts are pre-9/11. What's the latest date for a material fact for any of the detainees?
I think the last detainee was transferred into Guantanamo in about 2006.
Let me ask a question that I think common sense Americans would ask, and this is not a rhetorical question. Since many of these people are detained because of their alleged conduct on or prior to September 11, 2001, why hasn't there been some prosecution of them in the nearly 10 years that have taken place since then?
Well, as you know, Congressman, we're making efforts in that regard.
I appreciate that, although I think, and I'm fully aware we wouldn't want you ever to speculate in a way that would undermine your case, but it's a pretty good rule of thumb that the older evidence is, the more difficult it is to present to a finder of fact, isn't it?
That is correct.
So, I mean, I'm a little troubled that I don't hear a sense of urgency about moving the prosecutions more quickly, because the older these things get, the staler they get. Am I wrong about that, or?
You're generally correct that the older the facts get, the harder they are to prove up in a trial. The Commission's case against the 5 alleged 9/11 conspirators was dismissed without prejudice in January 2010, figuring out the forum for that is under review right now.
We would never want you to take a position contrary to your good judgment or the law, and I know that you won't. But we'd also want some sense that, you know, the earlier resolution of these cases is better on any number of scores, and I think I would personally urge you to give whatever urgency you could to that process. I would yield back.
Thank you. Mr. Whitman.
Thank you, Mr. Chairman. Secretary Lynn and General Counsel Johnson, thank you so much for joining us today, and thank you for your service to our country. Wanted to talk a little bit, there were some assertions earlier on about the bill and about detainees going to Guantanamo and then staying there. I wanted to talk a little bit about recidivism, because there is an element in the bill that talks about certification of countries where these detainees would go, and making sure that we're looking at ways to reduce recidivism. So I wanted to look at the unclassified DIA reports, and specifically looking at recidivism from 2004 through 2008. The rate varied between 5 and 8%, but if you look at the recidivism rate since 2008, we see that it's at about 25%. So there's been an increase, and the question then becomes, what's caused this increase? And it's been fairly dramatic in recent years. So my question is are those increases, is it due to a release at a higher rate of those detainees, or is it a change in reporting criteria, or is it improved monitoring, or is there something else? We really want to try to get at what's the cause behind this recent rise in recidivism since 2008?
It's always hard to assess, but it takes a while to just understand the evidence of who is a recidivist. So in some cases, what you're seeing is not an increase in recidivism, it's an increase in our understanding of recidivism, because in some cases the reentry process takes a while, and then it takes a while for us to gather the evidence to find that. As I said, the numbers before is that there were about 540 detainees released 2008 and prior, and there have been 67 since. I don't think it's an increase in a rate in the 67. It's a discovery of the recidivism rate of that total of a little over 600.
So if we're talking about the rate then, and looking at what may or may not be the cause behind that, let me ask a little bit about pre-transfer security assurances. I know obviously the countries that they're going to, we want to make sure that those countries are doing everything they can, practicing their due diligence to make sure that those detainees don't make their way back to the battlefield. Are you confident in the pre-transfer security assurances that those countries are providing us when we enter into an agreement to transfer a detainee there? Do you think that they are putting in place the proper controls to make sure that those detainees don't end up back on the battlefield?
We've negotiated very seriously through the State Department those security assurances. We take them very seriously. We ask for very stringent security assurances. We've tried to improve the process based on just the recidivism recognition of that rate that you've said. We've moved away from block transfers that were done before, and we only do transfers now on an individual basis, so we have assurances for each individual detainee as opposed to a block. We have been working with the individual countries, and frankly, where we find some backsliding by individual countries, we tend not to pursue further transfers with those countries. So we are conscious of the process and what you're talking about.
You talk about making sure that you are diligent with those countries and making sure that they are properly practicing due diligence and keeping up with those detainees and making sure there's no backsliding. I'm assuming in those instances you mean that you won't pursue agreements in the future if those countries are backsliding. But let me move on to another area, and that is rehabilitation and really being aggressive with countries in rehabilitation programs. So the ones that do have detainees that haven't backslid, is there an effort there to make sure that they have programs to rehabilitate these detainees to, again, make sure that they're not going back to the battlefield, not only making sure that they keep up with them, but making sure that they're engaging them in ways that don't have or don't create opportunities or incentives for them to go back to the battlefield?
We have engaged in those discussions. The major rehabilitation program is in Saudi Arabia. It's a very strong program. It's a lengthy program. It involves spiritual advice. It has family engagement. Nothing is going to be 100% effective, but we think that they have put in place a logical, sensible, and a strong system.
Okay. Thank you, Mr. Chairman. I see my time is up. I'll yield back.
Thank you. Mr. Cooper.
Thank you, Mr. Chairman. I have no questions at this time.
Thank you, Mr. Chairman. First of all, I'd like to thank the Chairman and Ranking Member for working together on this. I think it's such an important issue of national significance that needs to be a nonpartisan way of approaching this, and I would really like to thank them in leading our committee forward this way. Just a couple of questions, and I appreciate our witnesses being here. The 168, I think, remaining detainees, is that about the right number?
I think it's a couple more than that.
Is there an assumption that should be made of being that we have released, I think, the number 500 and some prior to 2008, 60 some since, that almost 600 then have been released? Is there any assumption should be made that, I know that some of the ones remaining are still in the fight, that there really is little hope, I would think, that we'll ever change their minds, but the rest of those guys there, is any assumption should be made that these are more dangerous than perhaps the ones that have been released, or are these just unfortunate they got caught in the process and the process has kind of stopped?
I think you should assume that the 48 that we have determined should be in long-term detention, that determination was based on a review of the threat that they pose, and those are the ones that I used the President's description, said that they continue to be at war at us and they continue to pose a significant threat to our national security. So I think you should assume those are indeed more dangerous than the ones that we've released.
And then the 100 and some that aren't that 48, is it just, once again, is just a matter of the process has failed to move forward for whatever reason, and they're just got caught there?
There are three principal groups in there. There are some that we plan to prosecute. I think the number's 36 that we're looking to prosecute, and we're proceeding on that process either in an Article 3 or a military commission forum. The remainder then are detainees from other nations where we have not been able to find an appropriate transfer location where we get the appropriate security assurances, and we are continuing to review that. And then there is a large population of Yemenis, and the President has determined that given the situation in Yemen and the fluid situation and the strong presence of al-Qaeda, that is not a nation that we can send detainees back to.
And one time before,
at this time,
in hearings, and Ms. Johnson, it might have been you that I asked the question to. At the time, I was told that there's nothing that we're considering that should be any influence to the people on the battlefield in terms of they fight their fight, they take care of their business, they look after themselves and defeat their enemy without having to worry about, Miranda rights or anything like that. So there's nothing that's going to back up to the battlefield that we're talking about now. Is that correct?
That is correct. I don't believe that it's the job of a soldier or a Marine at the point of capture to be reading somebody their Miranda rights. Yeah. It's that they're not in the business of evidence collection or arresting people. They're in business of engaging the enemy on the battlefield.
Well, and I would just like to conclude by agreeing with my colleague, Mr. Andrews, and the sentiment of others that have been expressed here. It's this 10 years, time has drug on. It's time to make this process start working, and I appreciate y'all's effort to do this, and once again I appreciate the chairman and ranking member for working together to move this process forward too. Thank you.
Thank you. We not only have to work together, there's another body also. So there are a lot of us that need to work together, and I think it's a very important issue. We'll continue doing so. Mr. Rooney.
Thank you, Mr. Chairman. Mr. Chairman, I think somebody said that this isn't a markup, but to me it's kind of feeling that way, and especially when the ranking member said something about what our bill could or might do, and I jumped up and asked staff, said, wait a minute, that's not correct, and they said, no, that's not correct, and I think that it's also kind of interesting that Mr. Andrews' line of questioning, which I usually wouldn't agree with 99% of the time, I completely agree with, and I feel like hopefully this is an opportunity, and it's not something that we're missing by talking about this in a way that you're starting to see a kind of a unified front up here in what we should be doing after 10 years versus, what we have done. And whether it's Article 3 or military commission, we have worked together with the administration. We've worked together as a Congress to get military commissions where they are. And, as a former judge advocate, and somebody who's talked to defense counsels and members of the JAG Corps, I kind of feel like we have the system in place we need, and the problems with Article 3 and evidence and intelligence and that kind of thing and cost really are pushing us in the direction to just let's get something done here. With that, I want to ask really quickly, I have a lot of questions here, so I want to try to get as many in as I can. To Mr. Secretary, just generally speaking, philosophically, do you believe that the military commission system represents the values of our judicial system?
Yes, I do.
Do you think that the military lawyers, both defense and prosecution, are generally capable and fair?
We have superb lawyers on both sides.
Do you see intelligence problems and the divulgence thereof, either with sources or methods or gaining evidence and using that to prosecute in an Article 3 court?
I think that's one of the considerations as you decide which is the better forum between Article 3 and a military commission is how best to protect the sources and methods in gathering intelligence.
I guess what I'm getting at is if we've got military commissions that we think represent our values, and you yourself said a lot of these guys down there are still at war with us. The Department of Justice wanted to try to move some of these guys to New York because they attacked civilians, but it was an act of war. If military commissions represent who we are and our values, and the lawyers and the prosecutors and defense counsels are people that we can all be proud of, and that due process can move forward and protect our intelligence and our evidence, why aren't we doing it? I mean, why aren't we doing it and just forget about Article 3 when it comes to the people we have at Gitmo?
We think that would be a one-size-fits-all approach. We think the better approach would be to use all of the tools we have in our judicial system, the Article 3 approach, the military commission approach, take the approach that best fits the circumstances of the crime and proceed down that. As you said, both reflect our values, but in some cases we are better able to proceed down an Article 3 path where we've had considerable success prosecuting and convicting terrorists, several hundred in the last decade alone, or in some cases the military commission path is the better given the way the evidence was collected, given the location of the alleged crime. And what we think you ought to do is to decide which is the better forum based on the circumstances of the case.
Do you think the administration should do that unilaterally without Congress?
I think the decision on prosecution is an executive branch decision, yes, sir.
Okay, let me move on because I'm running out of time. Mr. Johnson, if we could move into the executive order specifically with regard to the Periodic Review Board, which is another level of review, which may not be a bad thing. I'm not saying that, but it's something that the President decided unilaterally. When the President's executive order, it contemplates that the government will need to turn over vast numbers of documents, here again, discovery, including all relevant mitigating information. That's a broader standard that's even used in our habeas cases in Federal court. Are you concerned about the breadth of information that we would be potentially turning over in discovery?
Without a doubt, we're going to have to put in place a system and personnel to deal with this review process that has been established. I do think it is appropriate for the detainee, for a law of war detainee, to have the opportunity to see the evidence consistent with national security. If there are circumstances where, for classification, we can't share it, we won't share it. But I do think it's appropriate that the detainee have the opportunity to see what the government has, and for the board to as well.
And if I could real quick, just also in the executive order, the detainee qualifies for continued detention whether or not they constitute a significant threat to the United States. Could you try to explain to us in as easy as terms possible, what does a significant threat mean?
I think that the term will likely be better addressed in the implementing guidelines. I also believe that the term will develop some meaning as we go forward in the actual evaluations. I can tell you that that term, in the drafting, there was no conscious effort to some way raise the bar so that we would be releasing more people. So that was not the intent behind that phrase.
Mr. Chairman, I'm over time. I appreciate your answers. Thank you. Yield back.
Thank you. Mrs. Davis.
Thank you, Mr. Chairman, and thank you both for being here and for your service. How do you plan to deal with those prisoners that have been detained at the detention facility in Parwan on classified evidence alone and evidence that we can't not turn over to the Afghan government? Is there a plan for how these prisoners will be tried, and are there plans to move them anywhere else? And what is the percentage really of detainees at the DFIP who can be turned over to the Afghan government for court trial? Are there any who can be?
As we go through the detainee review boards in Afghanistan, at Parwan, I think we find generally between a third and a half of the detainees could be referred to prosecution, and I think if I remember correctly, that the Afghans are preparing about 400 cases pursuant to those referrals.
On that issue of information that we can share or in many cases not share, how do you deal with that?
Well, it has to be done on a case-by-case basis. I don't think as a broad matter that it's posed a problem in terms of prosecutions. There are probably individuals where we've had to withhold, but in most of the cases we've been able to share the appropriate information to allow the Afghan government to proceed.
Is there anything about the facility that that is an issue in terms of their Parwan's reintegration program? What kind of success or lack thereof have we seen? Have any of those detainees been released by the review boards, and have they come back in any cases? What do we know about that?
One of the reasons that we constructed the facility at Parwan is that we found that the old facility, which was basically an old airplane hangar that had been converted into a detention facility, actually promoted an increasing radicalization of the population, and that by having a more modern facility with appropriate security safeguards, but better conditions for the detainees and a better ability for the guard force to monitor them, that I think we have been able to address that issue of increasing radicalization.
Do we have any numbers in that regard in terms of the number of successful individuals who've been reintroduced back into society, or and what do you determine success? I mean, is that basically?
I do not have numbers for what's the releases from Parwan as to where they've gone in society and what the success rate is.
All right, thank you. I yield back my time.
Thank you. Mr. Schilling.
Good evening, fellows. There's a couple of things, a couple questions I want to get to. In fiscal year 2011, the Defense Authorization Bill, Congress prohibited the transfer and release of the Guantanamo detainees to or within the United States. President Obama signed this bill into law, and then a week ago this past Monday, the White House announced that it would seek repeal of the restrictions imposed by Congress. Which aspect of the prohibition are you seeking to repeal? Are you seeking to move Gitmo detainees to the United States for detention or prosecution, or are you seeking to release the detainees into the United States, or all of the above?
The President, I think, has been clear that he thinks that we should pursue Article 3 prosecutions in the United States, and he would certainly want to see that repealed. He has been equally clear that we were not going to release detainees into the United States.
Is the administration still considering opening the Thompson, Illinois prison as a possible detention site for the detainees?
We would certainly like to close Guantanamo. Thompson was the location that we had identified to move the remaining detainees to. Obviously, we haven't succeeded in that in Congress at this point. I don't think we've changed course, but we recognize that we have quite a bit of persuasion to do.
So basically, Thompson, Illinois is still on the table?
To the extent there's a table.
Okay. And then have you looked at what the cost would be of relocating the detainees to the United States for detention? And then if so, how much would it cost?
At one point I had all these costs in my head. I'm afraid I don't right now, but I can tell you the overall assumption when we were doing the analysis 12 or 18 months ago, where there was an initial cost to moving to Thompson, but the costs of Thompson operations were lower than Guantanamo, and so the initial costs were paid back in, I think, a period of 2 or 3 years.
Okay. Very good. Thank you, and I yield back my time.
Thank you. Mrs. Hanabusa.
Thank you, Mr. Chair. Mr. Secretary, in the final report on Guantanamo, we have, of course, 126 who have been approved for transfer, 44 referred to military commission, 48 considered to be basically too dangerous, and 30 who are Yemenis who are in conditional detention. Who made the decision as to who would fit in each one of these categories?
There was an interagency review process that started with a task force that assessed all the intelligence, the legal, all of the information available on each of the detainees. That was reviewed by a deputies committee and ultimately by the principals committee of the National Security Council.
So it wasn't any kind of trial or any kind of a legal proceeding where whoever may be falling in whichever category had some kind of rights to either contest or to have a say?
This wasn't a legal proceeding. This was a review process. Most of these detainees have been pursuing habeas actions, and that's been their legal avenue.
That brings me for a question to Mr. Johnson. Of the habeas corpus petitions, I think 57 were filed, and 37 actually prevailed. So they were released in some form or another. Now, my question is, when you think of habeas corpus, you think about it in terms of our legal system and the criminal rights associated with it. Now, do those same laws apply when a detainee avails himself of habeas corpus?
A habeas proceeding is a civil proceeding. It's not a criminal proceeding. And in the habeas cases that are in federal court here in Washington, as the practice has evolved, we see that detainees' discovery rights have been expanding over time. In limited instances, I think it's the case that the district courts wanted to hear from live witnesses. That happens once in a while, but the practice has evolved, but it is fundamentally a civil proceeding with a different burden of proof. It's not proof beyond a reasonable doubt.
No, I understand that, but I'm saying that they avail themselves of the same rights that you and I might have if we were filing a habeas corpus proceeding. Would that be a correct statement?
Generally, yes. In the federal courts in the United States, yes.
And in that light, how many of these habeas corpus proceedings that they have prevailed on have resulted with civil litigation against the United States for either improper detaining, civil rights, maybe not civil rights in the classic sense, but have we had those kinds of basically liability exposure as a result of us losing the habeas corpus proceedings?
No, not really. There have been some cases brought by former detainees who were released or transferred back to their home country who then brought up litigation as a former detainee. We have not, the detainees have not had a lot of success in those cases.
But they have been brought?
There have been a few of them, yes, by former detainees.
Now, my other question to you is now, when the proceeding here is we want all the different rights available. Now, if you go to an Article III proceeding, which of course is our federal court system, and you touched upon the fact that when they're, I guess they're not arrested, but when they're picked up in a war situation, you don't have Miranda. So how and what set of laws are going to govern in a federal court proceeding under Article III? What kind of laws?
Basically, what the courts are doing is trying to evaluate whether the detainee fits within our definition of an unprivileged enemy belligerent. The AUMF, as informed by our definition of who we say we can detain. And that's not the application of any particular state or federal law. It's the application of the habeas remedy, and the courts are trying to assess whether the detainee fits within the AUMF authority that the Congress gave us. And in the cases where the government has not prevailed, it's been not through any, unorthodox legal interpretation. It's because there simply was not the intel that we were and the evidence that we were able to put together to justify continuing holding that person. There were some decisions that we disagreed with, obviously, and we've appealed those. But it's not the application of any particular body of law except for the habeas law that's developing now in these cases.
Thank you.
Thank you. Mr. Griffin.
Thank you, Mr. Chairman. Thank you all for your testimony today. I'd like to start just by clarifying something. I heard a reference earlier to the bill. I think someone indicated that an Abdul Muttalib situation where someone's picked up in the United States would have to be sent to Gitmo under the bill. That's not the case. They would just simply be detained by DOD, and they would not necessarily have to go to Gitmo. But just want to clarify that. Mr. Secretary, I want to talk a little bit about the Abdul Muttalib situation. If that sort of incident, Christmas Day incident, were to happen today, would DOD be consulted in any way? Is there a role for DOD to play in that process if it were to happen today? And
yes.
Both of you, yes.
Yes.
Could you elaborate on that?
I believe
part of written protocol, or is this just?
No, it's not part of the written protocol. But I hesitate on hypotheticals. But
sure,
if an individual who had attempted to commit a terrorist act and it appeared that he was part of AQ or an affiliate, in other words, he had trained at a camp, an AQ-run camp, were arrested here in the United States in the process of trying to commit a terrorist act as part of the ongoing conflict, I believe it's the case that we, along with the intelligence community, the interagency, would be consulted about the disposition of that individual, yes.
Okay. If there's any doubt, would you confirm that and maybe get back to us on that, just if there's any doubt? I mean, if the answer is yes, the answer is yes. Secondly, Mr. Secretary and Mr. Johnson, this may be better suited to you, Mr. Johnson. Many members I've talked with here have had serious concerns about allegations that sensitive materials have been provided to detainees, potentially through their attorneys. And my understanding is there is a security protocol in place for federal habeas corpus cases that provide for sort of a walled-off privilege team and to ensure that the classified information is not passed. My understanding is there's not such a privilege team in the military context. And so if you could comment on that generally and let me know whether we plan to keep things as they are or possibly have something like that enacted.
We have, one of the things I discovered is that we do not have a similar protocol in place for commissions cases like the one we have in habeas cases. And so the convening authority has developed one. He recently settled on the document and he put it out to the defense counsel for comment. Imagine the defense counsel are not too happy with it. And so the convening authority and the defense counsel will consult each other on the document that the convening authority proposes to put in place, which is modeled after the privilege team protocol for the habeas cases. And there are a number of other reforms that I think we put in place over the last 12 months or so to deal with the situation that you've described.
Okay, great. And I assume at the appropriate point we could get a briefing on that maybe. And lastly, I've got just a short amount of time here. In response to one of the 3 executive orders that President Obama issued in January '09, my understanding is the White House established an interagency team to question terrorists known as the High Value Interrogation Group. DOD was involved in the creation of this group, that's my understanding, and plays a role in its operations. I don't want you to disclose anything that you shouldn't. Understand you can't share maybe specific details, but could you give us an idea about how well this group is functioning, whether this has been a good development?
I haven't heard of any issues.
I think I think it's only been used in a couple of instances, and I don't think I can go further than that here. I think we've set up the processes, and the intent here was that we would have the ability to fly subject matter experts to a potential capture so that we had people who had a base of knowledge involved in the questioning rather than just who happened to be there. And so I think that the principle is right. I think we've put the procedures in place to exercise it where necessary.
Thank you, Mr. Chairman.
Thank you, Mr. Johnson.
Thank you, Mr. Chairman. Gentlemen, thank you for your appearance today. And I had the occasion to visit Guantanamo, the facility in which the enemy combatants are being held. And I was impressed with the conditions that I could see under which they were being held. And I didn't see the particular cells that they are in, but is it six feet by 12 feet, something like that? Cells, you know?
I think they vary. Some cells are that size. Some there's more of a community-based process. So it's a variety. It's not a single cell size.
And what the high-value detainees, they are held in individual cells, correct?
I don't think in an open forum I can go very far on that.
Okay. Well, they're not shackled while they're in their cells, are they?
I think what I'd assure you, Congressman, is that with all of the detainees at Guantanamo, we are following very strictly the provisions of the Geneva Convention.
Well, I tell you, I didn't see any prisoners that were shackled while in their cells while we were there. And what time do they get up in the morning?
I'm not sure.
Yeah. Are they forcibly kept awake until a certain hour of the day before they can go back to sleep?
No.
And they're not forced to sleep naked?
No.
Not forced to undergo a strip search every morning?
No.
And but now yet a gentleman is being held in U.S. custody. It's Private First Class Bradley Manning being currently held at Quantico, charged with serious offenses. And let me state clearly and forcibly that if he's convicted of those charges, then he should be severely punished. But from what I have heard, what I've seen down at Guantanamo and what I've heard about the conditions of confinement for Private Manning, it seems to me that the enemy combatants are being treated better than he. And he is just simply an accused. He has not been convicted of anything. And I'm concerned about that.
Congressman, Private Manning is in pretrial confinement, which is a common thing in the military justice system and in our civilian criminal justice system. And there are a variety of reasons why somebody is in pretrial confinement before their trial. I think, frankly, that there's been a fair amount of misinformation.
So he's not being held in a 6 by 12-foot cell with 1 hour per day outside of the cell, and he's shackled while he's in the cell. And it's not true that he's awakened at 5 a.m., 7 a.m. on the weekends, and forcibly kept awake until 8 p.m., and routinely awakened in the middle of the night. That's not true. And it's not true that he's forced to sleep naked and subjected to naked examination every morning. Those things are not true.
Private Manning is, first of all, not in solitary confinement. He has never been in solitary confinement. That is a piece of public misinformation. It is public that he currently is in a classification status called maximum security. However, someone in maximum security at Quantico occupies the same type of cell, which is a single occupancy cell, I don't know the dimensions, that a medium security pretrial detainee at Guantanamo would occupy. The very same type of cell, and you could have a maximum security confinee and a medium security confinee there in the same row of cells, and they can in fact converse with each other.
But no one else is held under those same conditions of confinement, though, that Private Manning is being held.
Mr. Johnson, your time has expired, and perhaps Mr. Johnson can follow back with you off the record.
Thank you, Mr. Chairman.
Thank you.
And thank you for your answers.
Thank you. Mr. Bartlett.
Thank you very much. I am genuinely conflicted. We're one person out of 22 in the world, and we have a fourth of all the good things in the world. And I ask myself, how come? It's not because we any longer have the world's best work ethic. It's not because we have the most respect for technical education. This year, the Chinese will graduate 7 times as many engineers as we graduate. It's not because we have the most respect for the nuclear family, because nearly 50% of our kids are now born out of wedlock. Why is it then that we're so darn fortunate? I think a major reason is the enormous respect that we have for civil liberties. There's no other constitution, there's no other Bill of Rights that so defines and protects these God-given civil liberties. I think we put at risk who we are as the world's only economic and military superpower if we permit any erosion of these civil liberties. I note in the Constitution that it's people that are protected, not just citizens. I read it over and over again in the Bill of Rights. The expediency of the moment to enhance national security has resulted in indefinite detention of individuals, some of them even U.S. citizens, without any charges. And the President has made an incredible public statement that even if tried in court and found innocent, we're going to detain them indefinitely because we know they're guilty and are a threat to our country. If the expediency of the moment permits these bizarre rationalizations, Mr. Lynn and Mr. Johnson, I'm concerned that future rationalizations for national security could target you and me for indefinite detention and denial of our civil liberties. I have 10 kids and 17 grandkids and 2 great-grandkids. I obviously have a lot of reasons for maximum national security. But at what price? Dissuade me, please, from my concerns and free me from the torment of my confliction.
Congressman, I think you're right to be conflicted. I think this is we are in, with these detainees, we are in a difficult situation, in particular with the ones that I think you're focused on, which are the 48 that we have done frankly, a comprehensive review, and we've determined that they, as I said, continue to be at war with the United States and continue to pose a threat. Now, we have the legal authority to hold them as they've gone through their habeas proceedings, and the Court has held indeed that there is a legal basis for holding them. But I think the significance of the executive order, I'm not sure it's going to make you rest completely easy, maybe you shouldn't, but I think it should ease you some, is the significance of this most recent order is one part of it was to set up a process which is a continual review process of these 48. It allows for an initial review after 1 year and then file reviews every 6 months to ensure that we continue to believe these individuals pose a significant threat, that there's been no change in circumstances, no additional information has been found. We give them, we give the detainees a robust process to bring forward any information that they think is relevant, and then we have another comprehensive review every 3 years. This is, I think, intended to be a protection against exactly what you fear, is that this is somehow an indefinite detention authority without recourse.
What about the President's incredible statement that even if found innocent, we know they're guilty and we'll keep them detained indefinitely?
That's not a statement I've ever heard.
It's a statement I've heard widely reported, sir. Thank you very much, Mr. Chairman. I yield back.
Thank you. Mr. Larson.
Mr. Chairman, I just would alert anyone who wants to be next to go ahead and be next. Most of the information I need to get from the hearing is in the testimony, and just to be sure I'm understanding the process that the administration's executive order is laying out. I'll do any follow-up questions based on that at a later time.
Thank you.
Yield back.
Gentleman yields back. Mr. Wilson.
Thank you, Mr. Chairman, and thank you, Secretary Lynn, for being here. Mr. Johnson, as a fellow former JAG officer, I appreciate your service. I've had the privilege of actually visiting Guantanamo Bay 3 different times. Each time I go, with my background in the State Senate on the Corrections and Penology Committee, I am very familiar with detention facilities. It is a world-class facility. It is a facility where we have young people who are truly serving our country well. It was extraordinary to me to see the young National Guard members from Puerto Rico who were serving on my last visit. And it is so encouraging because, to me, illegal enemy combatants should be held in accordance with international law, as we did in World War II, even beginning further during the American Civil War. It was understood by President Abraham Lincoln that our Constitution is not a suicide pact. Keeping that in mind, a lot of American citizens don't understand. You correctly identified that persons being detained there are a threat to the security of the American people, American families. But also there are a number of people being held who cannot be released back to their home country for different reasons, such as their own security. Could each of you comment on the different reasons why we would hold people for an indefinite period?
Well, as I indicated earlier, there are several different groups that make up the bulk of the detainees in Guantanamo. There are the 48 where we've done this comprehensive review, and those are the ones that remain a continuing threat. There are the 36 who we are looking at the opportunities or the options for prosecution. There are a smaller group that is, we are continuing to look at transfer options if we can find the appropriate security assurances. And then there's a fairly large group of Yemenis who, many of which we would be, we think pose a relatively modest risk, except for where they would return to, Yemen. Because of the situation in Yemen and the strong al-Qaeda presence, these are not, I wouldn't call this indefinite detention in the same way as with the 48, but we don't have any options right now that would allow us to transfer them with appropriate security assurances.
And excuse me, go ahead, please.
Sorry, Congressman Wilson, I was with you on your last trip to Guantanamo, and you're absolutely correct that we've got a professional and a professionally run facility down there. The Guard force, as you know, is first rate. The point I'd like to make is that law of war detention of a congressionally declared enemy is not new. It is a very traditional concept. In a congressionally declared conflict, armies are supposed to capture and kill the enemy. And when we capture the enemy, we don't capture them for the purpose of releasing them, and we don't capture them for the purposes of all of them being prosecuted. So the concept of holding on to your enemy once you capture them is not new. It's very traditional. and it's an authority that the Supreme Court has said that we have.
Another thing that I learned that was so interesting that the American people can understand, so many of these were detained on the battlefield in the middle of Afghanistan. They were from, say, Uyghurs from China. There were Chechens from Russia. They would, on their person, they would have, say, $500 in U.S. currency, or they would have a particular citizen watch that maybe seemed very peculiar for somebody in the middle of Afghanistan to have, except for one thing. That particular watch had a timer. That meant that they were a graduate of bomb school. And so I truly support both of your efforts, and I am glad, I believe the President has now determined that Guantanamo Bay is a proper location for people who are truly a threat to the people of the United States. Thank you very much.
Thank you. Mr. West.
Thank you, Mr. Chair, Mr. Ranking Member, and gentlemen, thank you for being here today. I, too, had the opportunity a couple of weeks ago to go visit Guantanamo, and, of course, I've had, in a previous life, some trips over to various vacation spots, being in Iraq and Afghanistan. I think one of the things that we have to come to grips with, and what causes us so much consternation, is really to understand, are we dealing with criminals or are we dealing with enemy combatants? And if we're dealing with enemy combatants, are they legal or illegal enemy combatants? And so I'd like to ask a series of questions. The gentleman who shot our 4 airmen, killing 2 of those airmen in Frankfurt, Germany, do you consider that a criminal or an enemy combatant?
Congressman, I hesitate to comment on a particular case. I will say this, that the first thing I'd ask myself is this person part of the congressionally declared enemy in the congressionally declared armed conflict? That's the question I think we have to ask. If the person who commits a violent act against our military is part of al-Qaeda or an associated force, then that's something that may well be a matter for our military versus law enforcement. But, you know, you can't, it's hard to generalize here.
Well, see, I think one of the problems is if you go back and you look at World War II, I mean, in World War II, we did not go to fight the 12th Panzer Battalion or the 55th Japanese Infantry Regiment. So, I mean, we're going to see more of these instances where our men and women in uniform are being attacked. And I think that one of the critical things that we have to get to in this nation is really defining this enemy and defining the battlefield so we don't have these moments of indecision. I look at what just happened recently with the Somali pirates. I mean, we have 13, I believe 15 of them that we have now brought to the Norfolk courthouse for doing something where they basically commandeered a U.S. flagged vessel, being a civilian vessel, and executed 4 Americans. Now, history will tell me that back in the early 1800s, we had something similar of that happening, and we sent the Marines. Do you believe that these Somali pirates should be entered into our U.S. civilian court system, or should they be brought down to Guantanamo Bay?
Guantanamo Bay is intended for enemy combatants, and the enemy being the congressionally declared enemy. I think we have to be careful, and I'm sure you appreciate this, we have to be careful about the slippery slope. Not every action of our government against a bad person or even a terrorist should necessarily be a military action. We have to be careful not to over-militarize our approach to acts of terrorism. I think there is a place for law enforcement, not necessarily U.S. law enforcement of other well-developed nations. But I think that given this unconventional conflict we're in against a non-state actor, we have to be vigilant not to let the slippery slope creep into our thinking about who our congressionally declared enemy is in this armed conflict. And that's something that I have to assess almost daily in my job.
So if al-Qaeda were tomorrow to change their name to the Bombay Bicycle Boys Club, would they not be a congressionally termed enemy? I mean, would we treat them different?
If they change their name, hopefully our intelligence will be able to figure that out, and we would realize it's still like al-Qaeda.
I think the most important thing that we have to do is to not constrain ourselves and understand in this modern 21st century battlefield, and it's only this named enemy or that named enemy, because what is Hamas? And of course, before there was Al-Qaeda, the #1 terrorist organization that killed the most amount of Americans was Hezbollah. So do we not see Hezbollah as an enemy force? I'll finish up on this last question. 24 years of age, Omar Qadir, who is guilty of 5 war crimes, to include killing a U.S. serviceman, will be released out of Guantanamo Bay next year and sent back to his native country of Canada. What was the genesis of coming forth with this ideal, and how this deal, and how can you explain that to the parents of that American serviceman who was killed?
That was an arrangement reached between the prosecutors, the defense counsel, ultimately endorsed by the convening authority. As General Counsel of the Department of Defense, I don't make prosecution judgments or plea arrangements, and I'm not supposed to. I'm satisfied that the parties collectively did what they needed to do. And I also know that the victim's family was consulted throughout the process.
Well, I know that we talked about credibility, and I think the most important credibility we must maintain is the credibility we have with our men and women in uniform. Thank you very much, and I yield back, Mr. Chairman.
Thank you. Ranking Member Smith.
Thank you, Mr. Chair. Just a couple of closing comments on our side. I don't really have an additional question. I think the biggest thing is that I want to agree with the Chairman. There is a very strong need for the executive branch and the legislative branch to work together on this, and I don't think we've done a good enough job on that to this point. And I would strongly encourage the executive branch and the White House to work directly with Mr. McKeon and with the Republicans as we craft this legislation, because part of my concern is that, absent that sort of collaborative process, at this point we both sort of agree that we don't want to talk to both sides don't want to talk to each other about what they're actually doing until they present it, and then we'll fight about it. There's a real danger in that if the legislation gets moving in a direction that's not properly reined in. And I think that's some of my comments earlier about the legislation that was released last week, both by Senator McCain on the Senate side and here on the House by the Chairman. We do need the advice of the executive branch, and frankly, it's been there on and off, but I don't think it has been as active as it should have been working with the Congress, either Republican or Democrat, to say, hey, what are you talking about? Here's what we're talking about. Let's try to work this out. I think the question of the militarization of this is one of my concerns, and it may be true that under this legislation they would not be required to take them to Guantanamo if they're doing military tribunals, and that's where they're doing military tribunals. I would suspect that would be the outcome. But it is absolutely true that the legislation would put the military in charge of essentially U.S. prosecutions. If you had, crimes like the attempted bombing in Times Square under the new legislation, it would be the military that would be responsible for holding, trying, and interrogating that person right here on U.S. soil. That is extremely problematic to give the military that amount of power. And then you can ask the question, if you were trying to find collaborators who worked with them, who would be subject to this as well, who's doing that investigation? If the military is ultimately responsible for holding, interrogating, and trying these people, wouldn't the military then be involved in a domestic U.S. investigation to try to find who it is that they're supposed to grab? Those sorts of implications, I think, are alarming, and I think they would be alarming to the majority party as well once we played it out. But absent a collaborative process between the executive branch and the legislative branch, you wind up with that. And I think many of us would agree that the prohibitions contained in the National Defense Authorizing Act from last year had consequences that we'd rather not have seen, that came about because there was a battle and one side won, and that's where we wound up, instead of a collaborative process. So I applaud the Chairman for holding this hearing and would encourage greater collaboration between the executive and the legislative branch as we move forward with this process. Thank you, Mr. Chairman.
Thank you, and I appreciate your comments. And there's a reason for that. None of us has all the brain power to make all the best decisions, and I think the more all of us are involved in the process, the more chance we have of getting a better product and not making mistakes. And that's my whole purpose in this, and I'm sure we will we will work together, and I know that we're not far from the Senate in this. My goal is to have legislation come out that will be helpful in the war that we're engaged in. With that, thank you very much. The votes were postponed, so we were able to get through the hearing. I appreciate your patience. I appreciate all the members being here. And with that, this hearing will be adjourned. Thank you.
Thank you.